Good afternoon and welcome to COVID-19 Survival, the $2 trillion CARES Act and how your business can survive. My name is Nicole Atala. I am going to introduce you also in a second to my co-presenters, Cy Alba and David Schaefer. And we, as you can imagine, we have been doing a lot of work in reviewing the CARES Act and its implications. We've received a lot of great questions from clients, and so we thought it would be helpful for us to take a pause and review kind of the overview, the menu of options. I think one of the resounding questions that our clients have is, so what do I choose? What's best for me? And hopefully today we can give you some sense of different provisions in the CARES Act that will guide you to the best decision for your organization. We are from PilieroMazza. We're a business law firm that serves as a strategic partner to our clients and who are contractors and commercial businesses all across the United States. You will hear from three of us in three different practice groups today. I am in the employment practice group. This is Cy. I don't know, this might have been a few years ago, Cy. He is a partner in our government contracts practice, is very, very knowledgeable. And when they come on, they can say more about themselves if they want. This is me. This picture was taken before COVID-19 and home with my two kids, so I have a few more wrinkles now. And I chair the labor and employment practice. And this is Dave Schaefer, and he is in our Maryland or Annapolis office. Even though his address on here seems to say that he's in DC, he actually hangs out up in Maryland. So guys, did you want to say anything more about yourself?
No, I'm good. Thank you.
Yeah, only that I'm actually probably hanging out at home a lot more now, not in the DC or the Annapolis office.
Fair enough. Fair enough. All right, so what are we going to talk about today? We're going to talk about some employee-focused assistance that has been I don't want to say overlooked, but the loan relief is certainly on everybody's minds, and we will talk a lot about that today. Don't worry. But I wanted to, some clients have also asked me what else is in there, else is in CARES. So I wanted to highlight a couple of provisions that might have been overlooked or not focused on so intently by your organization to this point, but will help you in that decision-making process. Dave and Cy will then focus on the different types of loan relief and other business relief that are out there today. So our goal today is to give you the menu, to give you kind of what's in this thing, and some considerations that we've been working through with clients that we thought might be helpful for everyone to take note of. So let's dive in. So we only have an hour. So first of all, what's in there as far as employers and employees? I wanted to note very quickly that the Families First Corona Relief Act, which is the act that was passed 2 weeks ago now, I think, that offered sick and family leave to employees that were affected by the coronavirus, that goes into effect today. So if you haven't been paying attention and you're a business that employs less than 500 employees, you should be implementing a expanded sick leave policy and expanded FMLA policy that covers employees that either themselves are sick or that are taking care of people that are sick or they're home with children. So the 80 hours applies to those particular reasons. It also applies if the employee is home because of an isolation order, a state, federal, or local isolation order. That isolation order, as we all know, those isolation orders are coming out all the time. Right now, DOL is taking the position that if you're under a local isolation order that has closed your business so that you cannot go to work, then that employee would not be covered by sick leave, and we need to find one of these other things we're going to talk about in order to maintain that workforce if that isolation order shut down businesses. So that's an important point that DOL has been clarifying over the last week that I wanted to point out to you today. I also wanted to point out that for businesses that have less than 50, there's a lot of talk about exceptions, and it doesn't apply to certain businesses under 50. That only really relates to the child care provisions. And you have to show that it would threaten the viability of your business in order to qualify for that. So it's a very high standard. most businesses should presume that if they're under 500 people, they're going to have to provide sick leave. They might get an exemption for the extended family leave, and the extended family leave, that FMLA 12 weeks, would only apply for care of children. So we have more about FCRA and those leave requirements on our website. So please feel free to check the articles and blogs that we have written over the last week or two for updates. Again, that's evolving, but it is effective today. I wanted to bring a couple more things to your attention. So there is a payroll tax credit in CARES. And basically, an employer would be eligible for a refundable tax credit if you retain employees because of a full or partial closure, because of one of these local, isolation orders. So this is the part of the bill that you want to be paying attention to if the business has been closed or an employee is not able to work because a government authority limits travel, limits businesses being open, or limits group meetings due to COVID-19. Or if you just experience a significant decline in your business such that you need to lay people off. So if you retain your workforce that would otherwise have to be laid off because of these, that you would get a tax credit that's equal to 50% of the qualifying wages paid to each employee in each quarter, up to $10,000 per employee. This is not available if you take advantage of the Paycheck Protection Program and loans that we're going to talk about in a little bit. But if you don't qualify for those loans or you don't want to take those loans, this would be a really good resource to think about how can I take advantage of this payroll tax credit. You can also, if you're an employer, you can defer the employer share of your Social Security taxes that are owed as payroll taxes. They would have to be paid over the next 2 calendar years, half due by December 31st and the remainder in 2021 and the other half by 2022. So if you're in a pinch financially, you can defer your share of the Social Security taxes that might be owed as payroll taxes. Another interesting component of CARES is the student loan provision. So a lot of employees that might be hurting financially right now can't afford to pay their student loans, right? So there are provisions in this bill for them to, or law now, for them to get deferments on their payments. But also there's a temporary provision that allows employers to contribute up to $5,250 toward each worker's student debt through December of this year on a tax-free basis. So that might be, you might want to start talking to your tax advisors about how to take advantage of that $5,250 that you could contribute on a tax-free basis. That might be a good benefit to the employee and something that you can take advantage of to reduce tax liability. And I also wanted to talk, I've gotten a lot of questions about the expanded unemployment benefits. These expanded unemployment benefits, basically, it's called the Relief for Workers Affected by the Coronavirus Act. And it basically provides that where an individual becomes unemployed because of the coronavirus, they're either affected, they're unable to work because of the coronavirus in some way, shape, or form, they are entitled to unemployment compensation. They're up to 39 weeks of assistance. And the assistance can cover people during the period of January 27th of this year to the end of the year, December 31st. So it's a pretty decent period of time. And then in addition to whatever they would be allowed to get under state law, they're going to get an additional $600 per week. So when you're thinking about what your employee is going to be able to take away, when you take into consideration the sick leave they might be eligible for, some of these payroll tax credits, whether you go out and get a loan, take also into consideration, whether that $600 a week might put employees ahead of where they are even now working full time. So some employees have actually said to employers, thank you, but I would prefer to be laid off because I can take advantage of this extra $600 per week if I know it's on a temporary basis. So just keep in mind that that is out there. The retirement account provisions are also interesting. The retirement account provisions allow people that are retired to basically, it allows them not to withdraw what they would otherwise have to withdraw. But I don't want to really focus on that as much as I wanted to focus on employees that might want to take loans or distributions out of their 401ks because they're being financially hit. Maybe a spouse has been laid off and they need some extra liquidity in that particular realm. The common way to think about this is that normally we would advise employees to take a loan as opposed to taking a distribution out of their 401k because we don't want them to lose that money, right? You want to keep money in those accounts as long as you possibly can. But under this provision, while you would normally be restricted from taking distributions from a 401k, a 403b, or a 457b plan, the CARES Act would allow a plan sponsor to permit qualified individuals to take coronavirus-related distributions through December 31st of 2020. The aggregate amount of all of those distributions can't exceed $100,000. So you might be getting information from your plan, from your plans to make amendments or make commitments to whether you're going to allow this. I wanted to let you know it was out there in case that was something that you all wanted to take advantage of for your workforce. You do have a significant amount of time to make plan amendments. You can provide the benefit essentially to employees at this point in time, but you don't have to make plan amendments really for 2 years. So you have a lot of time in order to figure out what you're going to do on a plan amendment basis. Finally, I'm just going to briefly say that you should be looking at whether you have any local grants that are available. I know in the DC, Maryland, Virginia area, there are DC local grants small businesses can apply for in DC to give you quick infusion. There is also a Virginia relief grant that it doesn't cover payroll, but it covers other things because, you know, Virginia, I suppose, is saying there are other things out there right now for payroll. We want to help you with some other things. So look around, don't just look to the federal government. States and localities are also trying to do what they can to keep businesses functional until we kind of get out of the weeds here. So that's my 10-minute spiel on what really is in CARES, other than the loan relief that you might want to be thinking of. But I know a lot of you want to know what's available for businesses, small and large. So we're going to start with the small business loan relief that's available. I'm going to hand this over to Dave to give a high-level review of the Paycheck Protection Program and the Economic Injury Disaster Loan Program, and how you know whether it's right for you.
Thank you, Nicole. So, you know, both the Paycheck Protection Program and the Economic Injury Disaster Loan Program, the PPL and the EIDL respectively, are both loan programs that are under the Small Business Act. The PPL is actually an expansion of the pre-existing 7A loan program, and the EIDL is, as modified by the CARES Act, an expansion of the pre-existing disaster loan programs that are administered by the SBA. So starting off with the PPL, as I mentioned, the PPL is under the existing 7A program, but it was created entirely through the implementation of this CARES Act. And so, as the name implies, it's designed to cover the payroll of eligible employees and independent contractors for a certain period of time. And so it's really geared towards what are the payroll costs that you are incurred. In fact, the maximum loan amount that you can take is your average payroll cost for the trailing 12-month period, looking back from the date of which you apply, times 2.5 with a maximum amount of $10 million. So there are some other nuances to the precise amount that you can get, but that gives you the sense of what the intent of the program is for and what it's intended to do. And so once you get that loan, and I saw a question pop up about deferral, so I'll just make sure that I don't forget to address that real quick. Once you get that loan, and that loan is made through an SBA approved lender or through any other bank or financial institution that has applied for guidance from the Department of Treasury, and the Department of Treasury can make additional SBA approved lenders for the purpose of the PPLs exclusively. So it's administered by private lenders, and once they administer it, it's automatically deferred for a period of 6 months. There will be no requirement to make any payment of principal or interest during that deferral period, and the deferral period could actually be extended up to 12 months at the discretion of the lender. Now, interest will accrue during that time, but you will not have any sort of obligations to pay it. And then at the end of kind of the covered period, as used in the Act, you can actually apply for loan forgiveness, whereby you would apply to the lender with certain receipts and documentation demonstrating that you used the proceeds of the loan for an allowable purpose being payroll costs, covered mortgage, covered rent, covered utilities, and then the lender would forgive the principal amount, not the interest, but the principal amount. And there are some calculations with regards to how that piece gets adjusted up and down, which we can get into later. And so that's kind of one of the overarching programs. Right now, what we've seen from the Department of Treasury, it's going to be a 2-year loan with a 0.5% interest rate. And so that's one of the principal avenues that we're seeing out there, and probably one of the most attractive loan programs. The other one is the EIDL, the Economic Injury Disaster Loan Program. Again, that's an SBA disaster loan. This actually is administered directly by the SBA and not by private lenders. So for this one, you actually go to COVID-19 relief.sba.gov. That's the application portal that you can go to. But the intent of this program isn't necessarily to cover your payroll, it's to cover your damages. And so if your company, as a result of the COVID-19 pandemic, has suffered any sort of economic damages, technically it's substantial economic injury, which means that your company is unable to pay its obligations as they become due, you could be eligible for relief under this SBA program. The CARES Act actually modifies it a little bit to make it a little bit easier, and we'll talk to eligibility momentarily, but not only to be eligible, but it also authorizes an amount up to $10,000 to be advanced to you, and essentially it's treated as a grant. So whether you are denied the EIDL after your application, or whether you are approved the EIDL after your application, you will not have to pay back that $10,000, and that $10,000 is required to be paid to you within 3 business days following the submission of your application. Under this program, similarly, the entire loan amount is not subject to forgiveness. So that's just certainly something to keep in the back of your mind, but it's at a 3.75% interest rate, and the term can be up to 10 years, but it's really up to the SBA verifier and inspector who comes out and works with you to put that together. So Nicole, those are some of the high points about it. We can talk to eligibility or real quick if you like, or we can drill down on some other things.
Let's talk to eligibility really quick. There are a few questions that we can go over and some common questions that we get from clients.
Absolutely. So eligibility is a great question, because we're seeing it quite a bit. So the eligibility criteria for both of the programs, because the CARES Act has modified the EIDL eligibility, they're actually substantially similar. There are some nuances that are pretty minor, but on the whole, what we're looking at is small business concerns are eligible. Okay. Other than small business concerns that have under 500 employees, or 500 or under employees, or other business concerns who are below the applicable employee threshold for their relevant NAICS code, if there is an employee threshold in the size standards for the NAICS code, as well as certain tribal entities, veterans organizations, and nonprofits are also eligible under both of these programs. So the key component right now, in which most people have probably heard a lot about within the press, is that 500 threshold. And that's where, SI has been doing a lot of work with regards in particular to the affiliation analysis and making sure that you're counting all the W-2s that kind of fall under the auspice of your entity, whether through an affiliate or through that actual entity. But the eligibility for both is substantially similar. And related to that, you have to make a certification that you need the loan. You have to make a certification that you have employees, that you are in business as of February 15th, 2020 for the PPL. And so there are some of those other kind of more rudimentary qualifications. But on the eligibility piece, we're really focused on the employee threshold as the most critical.
And what if you've already applied for an economic injury disaster loan, but now you think that the Paycheck Protection Program might be a better option? You know, what can companies do that have already looked at the EIDL program?
Yeah, it's a good question because a lot of companies were very proactive, and before the PPLs were even available or even discussed, we're out proactively trying to obtain the EIDL. So there's a provision in the CARES Act that's called duplication, which essentially says you are allowed to participate in both programs, but you can't use the proceeds of each program for the same expense. So, for example, if you use the proceeds from your EIDL for April payroll and you go out and you get a PPL, you can't use it for April payroll, but you could use it for May payroll because that's not the same expense. So you can get both, provided that you don't use it for the same expense. If you get an EIDL actually made to you and approved prior to the PPLs being made available, and we interpret that as being made available to the public, which we hear could be as early as Friday. If you receive an EIDL prior to that, you can actually refinance your EIDL into your payment protection program loan. That will increase the maximum amount that you're authorized to borrow. So it would be payroll cost times 2.5 plus your EIDL that you're refinancing. And then that would allow you to apply for forgiveness of that particular EIDL as well. But if you get an EIDL after the date in which the PPLs are made available, you will not be able to refinance it if you get the PPL. But you still can get both, but you won't be able to refinance, and therefore the EIDL may not be subject to being forgiven, but you can get both as long as they don't cover the same expenses.
What about the $10,000, grant in 3 days that is kind of being advertised as immediate relief? How does that factor into either of these loan programs?
So under the EIDL, it's an advance, but it's an advance that you don't have to pay back. So essentially, as soon as they give it to you, that portion of the loan is forgiven. If you refinance it, you still don't have to pay it back, and that amount will be reduced from your loan forgiveness amount. So the bottom line is, once you get the $10,000 from the EIDL program, it's yours. It will not accrue interest. It will not be subject to repayment.
Okay. There are a lot of people that are concerned about, what's the catch, right? And because it seems like maybe this is a little bit too good of a deal, right? And so we're getting a lot of questions about how you're going to get loan forgiveness and what are some of the hiccups in getting loan forgiveness. For example, what if I had laid off people? Do I have to bring everybody back? Can I reduce salaries? That kind of thing. Can you speak a little bit to how you're going to qualify for the loan forgiveness piece of it, and what you need to be on the lookout for to make sure that you can get the most back?
Yeah, absolutely. And it's a great point because the loan forgiveness piece, as provided for in the CARES Act and applicable to the PPLs, it can get a little bit complicated. And it's best to always keep in the back of your mind kind of the intent of the program, which is to maintain a workforce and make sure that this money goes towards payroll. So you get the loan, and then whatever, there's 4 buckets of payments that, or costs and payments, that if the company incurs the cost and makes the payment out of the proceeds of this particular loan, that those amounts can be forgiven. And those cover down on payroll costs, covered mortgage, covered utility, and covered rent. And for mortgage, utility, and rent, the contractual obligation to pay those amounts must have arisen prior to February 15th. So obviously you can't enter into a lease agreement today, use PPL to pay it and get that forgiven. It has to have occurred prior to the disaster really unfolding. So you want to take a look at, in order to submit for forgiveness with the lender, because you're going back to the lender in which you originated the loan with, you're going to need to provide documentation, essentially receipts, demonstrating that you made the proper utility, rent, mortgage payments. You're also going to have to submit your insurance filings, tax filings, payroll filings, and those types of things to really prove that the money went where it was supposed to go. And so when you're thinking through on the front end, how do I prepare for this loan to be forgiven, you have to start tracking down the documentation to really understand exactly where it needs to go in order to be forgiven, which again is into those 4 buckets. And it can be used for other costs, other permissible costs. However, it cannot be forgiven unless it goes into those 4 buckets. And then that sets your baseline loan forgiveness amount, kind of the maximum that can be forgiven. And it's the costs incurred and the payments made during the 8-week period following the date in which you get the cash. So the intent is to pay people for 8 weeks following the day that you get your loan. And so it is the loan forgiveness amount. There's a couple ways that it could be reduced. It could be reduced, as Nicole alluded to, if your FTE headcount drops. It can be reduced if the wages of the employees are reduced beyond 25%. And there are certain metrics and calculations within the CARES Act that would have kind of a corresponding decrease in the amount of loan forgiveness that would be afforded to you if your FTEs dropped and if the wages, again, drop in an amount greater than 25% for such applicable employees. There's a provision in there in the rehire section whereby you essentially have until June 30th to eliminate those reductions in whole, not necessarily in part, but restore the number of FTEs, bring people back to work, and restore wages again up into to the point of that 25% threshold. So there are some of those provisions. It can be a little bit of a process to work through, but it's certainly something that you'll want to keep in mind as you contemplate how much money I'm going to get, what I'm actually going to do with it. And if you're really banking on the forgiveness component of this, then you want to make sure that it's going to those 4 buckets, those 4 permissible uses.
And just to clarify, there's one clarifying question that came in, and to clarify eligibility, there is no gross receipts limit on the PPP eligibility. It's just 500 employees, correct?
That's right. If you have 500 or less employees, the revenue component does not matter.
And when you're calculating the 12-month average for, do you use when you apply for the loan? Do you use the last payroll in March? Where do you start looking back for that 12-month average? Yeah,
it's the date that you apply for the loan. So if you applied today, it would be a lot simpler because it's the end of the first day of the month. But if you apply you can apply for this loan through June 30th. So you can apply from hopefully this Friday through June 30th. So the date in which you apply during this period, you look back 12 months from the date of that application. Now, just as a cautionary note on timing, there are $349 billion allocated for this particular program. And while it feels like a lot, and it sounds like a lot, the number of applicants and inquiries that we're receiving and people that we've spoken with, we're expecting a very large tidal wave of applicants in the early days. And so those who are thinking that they would prefer to wait until June may be out of luck. So just as a kind of a cautionary note.
And do you know what off the top of your head, what the interest rate is for the PPP loan? It's the same as the regular 7A loan, right?
So actually the Secretary of Treasury came out yesterday and declared, because there is some flexibility on what it could be, and declared that the interest rate is going to be 0.5%, but it's going to be a 2-year loan. So you have 2 years to pay it back, get it forgiven. Okay,
great. What if you just started a company in January? I assume that you'd be looking, there's a different look back period if you've just started a business. Do you know what
Yeah.
employers that just started up should be looking at?
Yeah, so instead of doing the trailing 12-month period, you would do essentially January 1 through February 29th. You would do the average monthly payroll cost for the 2 months before March. And this, it also is a little different for, say, seasonal workers. If you're a seasonal employer, then you would look to the February 15th to June 30th period of 2019 to determine your payroll costs for determining your maximum loan amount.
This might be a question more for Cy, but we have a question about, government contractors often just naturally have contracts that came to an end. And if you had a contract that came to an end yesterday, you're losing a bunch of employees, not necessarily due to COVID, but because the contract came to an end. How would this impact their ability to get a loan? Because the dip in their, April PR might be a little bit different than it was in the last year.
Yeah, so it doesn't necessarily matter that it's not really a question of, because for government contractors, my contract ended. That's not going to give you any special coverage other than what's in the act. So if the individuals, if you had to lay people off and you're bringing people back to work, in theory, you could have some of this cover that issue, but you have to bring the people back. I think we're going to get into those rules a little bit later.
And you would still have to certify that, the economic uncertainty of COVID essentially necessitates the leave. And I know that's a question. What does that mean to have it be a necessary loan? You don't necessarily have to show that you've taken a huge financial hit right now, but you do have to make sure that you have the right number of FTEs and all of that stuff in order to make sure that you can get loan forgiveness.
Right.
Right. Did you address, or sorry, go ahead.
Oh, no, I was just going to say, and I guess in theory, if you were expecting to put them on other work and then that other work got delayed, I think that would bolster your ability to say that this was something that you had to keep these key people on board. It was necessary for your business, or that the government told you they were going to turn back on some other contract. But the whole question of what's necessary under the act is very gray right now. And I think that's a big question that we keep getting asked, and we're hoping to get some more guidance later this week on that.
Great. Did we address the salary threshold of $100,000, Dave? Have you addressed that issue yet? We're getting a couple of questions about whether you have to exclude employees that are making more than $100,000 or whether just the amount of salary over $100,000 would be excluded.
Yeah, no, we haven't addressed that, and it's a good question because when calculating payroll costs, there is a specific exclusion, and it uses that $100,000 threshold. And our interpretation of that is that it excludes the salary in excess of $100,000, but not the payroll costs associated with the employee who happens to make that much money. So it's more of a cap on the salary, not an exclusion of the individual in its entirety.
Yeah, and kind of a follow-up to that, if we're talking about costs that have to be excluded from the PPL loan forgiveness, if government contractors get reimbursed for paid leave, and they get reimbursed for paid leave, period, either under Section 3610 of CARES, which we'll get to in a minute, or frankly FCRA, could you also qualify for a PPL loan? And I believe the answer to that question, guys, correct me if I'm wrong, is that you can't double dip, right? So even if it's a qualifying, you might qualify for the loan, but you can't double dip. You can't get paid for somebody's leave and then ask for it ask for that piece of the loan to be forgiven as well.
That's right.
Right. Okay, let's move on to, we've got lots of questions coming in, but I want to make sure that we get through all of the different types of relief. And so I'm just going to quickly talk about what I'm calling the other loan program, because I don't have a good name for it right now, but it's under Title 4 of the CARES Act. This is basically a loan program that's going to be provided to larger businesses that wouldn't otherwise qualify for loan relief under the PPL, for a PPL loan or other types of disaster relief. We don't really know much about it right now, which is why there's not a lot out there on it. But the Secretary of the Treasury is supposed to, they have been allocated money in order to do a number of things for certain industries and for mid to larger size businesses. We are waiting to get additional guidance on what that might look like. It looks like it's going to be a loan program of some sort, but we just don't have much information right now. But I did want to put it out there because I'm getting some questions from larger businesses or businesses that employ more than 500 people at least that are saying, is there a program out there for me? You might be able to take advantage of some of the other, benefits and cares that are not loan-based, like we discussed on the first slide, and then we're waiting to see what's going to be in this kind of quote other loan program. We also wanted to address this contractor-specific relief, and I'm going to turn it over to Sai to give a overview of what that looks like in CARES.
Yeah, and so there's this other provision that I know a lot of people have been talking about, and it allows contracting officers latitude, just like there's an OMB memo that's been issued. There's some guidance at DoD. Other agencies are starting to do it as well. And the main thrust of all of that, including the provision in this act, is that contracting officers should feel empowered to ensure that people are still at work, just like all these loan programs. And more importantly, arguably, to the government with a big G, is the idea that the industrial base, especially the defense industrial complex, will continue to be there and exist to support the government. And so because of that, there was a single provision, basically one paragraph, that was put into the act. And it says a few things. First, there's been focus on this section, which says, notwithstanding any other provision of law and subject to the availability of appropriations. And the important thing about that first part is people have asked questions about the appropriations piece of it and said, well, what if they run out of money? What if my contract is incrementally funded? Things of that nature. Well, it goes on to say that that the funds they can use to pay this are funds available to the agency by this act, meaning CARES Act, or any other act. So literally all funding for executive agencies comes from an act. And so they can take money from anywhere that they have it in order to pay for this. It doesn't necessarily have to come directly from the contract. I do think that it's probably going to be the case that in most situations, if it's a funded contract, they're going to take the money for this from those funds. However, if it is a incrementally funded contract, they would have to, or my guess is that what they would do is go through the same process. That just makes sense because they're going to have to be able to get the money. The easiest way to get the money is through that same process. So that's where the money piece comes from. The next portion of it talks about, okay, well, what sort of reimbursement or how can I get the money? And it says that they're allowed to modify contracts without consideration, so do it unilaterally if they wanted to reimburse, and then this is the important part, the quote, minimum applicable contract billing rates. Now it does say that that can't exceed 40 hours a week, and the next part talks about paid leave, including sick leave that the contractor provides to keep the employees in a ready state. However, the fact that it says minimum applicable contract billing rates and not cost means that they're not directly tying it. The act, as I read it and what we've been telling folks, is that it does not directly tie it into the costs. The government has decided, Congress has decided that they will, quote, reimburse you for all of those paid leave and sick leave and everything else. But how are they going to do it? They're not going to reimburse you at a cost dollar for dollar basis. they're going to reimburse you, at least through this particular clause, as just by giving you the minimum applicable contract billing rates for up to 40 hours per person. So what's important there is that would mean if you're on a labor hour or time and materials contract, you already have minimum rates in your contract that you already negotiate. They're sitting right there in front of them. So you should be able to just take those rates and they can effectively turn on your contract, not the work, but as far as the payments and the invoicing and whatnot, they could turn that back on. And I've heard from a couple contracting officers that have actually done that. I don't think it's that widespread yet because maybe some are waiting for guidance. But the fact is that that's what the law says, that they could do that. That being said, for firm fixed price contracts or for contracts, let's say you're paid per deliverable or something to that effect, that is a little more confusing. However, because of the OMB memo and other things in conjunction with this, contracting officers should be able to negotiate with you rates and then amend the contract appropriately to include those rates for this period of the crisis through and up to September 30th, 2020. So if you sit down with your contracting officer and come up with actual rates, that is allowed. Whether or not some contracting officers will interpret minimum applicable contract billing rates, especially in those firm fixed price or other kind of strange payment term type contracts, they might interpret that as meaning just your cost. However, there is a basis, like I said, to push back on them and say, no, these are supposed to be rates. You're supposed to just turn us back on and negotiate our rates. And had this firm fixed price or deliverables based contract been T&M or labor hour, this is how we would have done it. Now, even then, even if someone's willing to walk with you down that path, they might still ask for cost and pricing data to try to determine reasonableness or still push back on profit. So just be aware of that. You might have to go get some of these other loans we're talking about to pay, or just standard loans to pay yourself if you're an owner, that if it all comes out of profit, if you're not on the payroll. However, there's been some talk about, is there a way to put yourself on the payroll effectively up to that $100,000? And if you've done that before, it'd obviously be easier. The next piece to remember in this provision is that it's for contractors whose employees or subcontractors cannot perform work on a site that's been approved by the federal government, including federally owned property, and who cannot telework, but it has to be because their job duties cannot be performed remotely. So if there has been a shutdown of a facility, whether it's a contractor approved facility where the government knows you're working and they said, fine, that's where you have to do your work, or if it's a federal facility and your people need to go to the office and they can't any longer, then that's when this whole thing we're talking about is triggered. Same thing with if your people cannot telework, because two things. One, their job just doesn't allow them to do it. Or the way I read this, it would also include employees who could, in theory, telework to do their job. However, it's somehow tied to things that are going on site. And because of COVID-19, they can no longer get the input sufficient to do their output, even though they can technically telework. I would say this would still cover them. And so you can negotiate with the contracting officer to get those payments, as we talked about before. However, what I think is different here, or key thing to note, is that if the government is simply cutting back because they say, well, I don't need that work anymore because the airlines aren't running, let's say. So I don't need that services because there aren't as many airlines, so I don't need to track it or whatever I'm using for you. I don't need that anymore. That's not a facility being shut down or people not being able to perform their work at a approved government facility. So that arguably falls outside of this. However, the OMB memo and the DOD memo, I think that still gives pretty broad authority to contracting officers to feel empowered to do it. I think when you wrap all these things together, the key is going to be to present a case to the contracting officers about why either your employees are critical, why what you're doing is if they don't turn you back on, you're going to lose people. If they don't turn you back on, you won't be able to come back as fast, and it's critical you come back. If they don't turn you back on, and if they don't do this in a broad way for everyone, it's going to have this deleterious effect on the defense industrial base. So I think it's contract by contract basis, making arguments about why things work for you and why it would be appropriate to turn you back on is going to be critical until they come out with some broader guidance, which we have already talked to SBA particularly about putting out guidance to say, let me explain to you contracting officers what this means. It effectively means you should turn your contracts back on, especially for small businesses, if not in a broader sense. And we're also trying to work with OMB and people at the White House to broaden this up. I will tell you what I've heard through the grapevine is that the reason that there's some trepidation and why you look at this language in the act or the language in the OMB memo and why it seems vague is because they're not sure they want to put out explicit guidance that the world can look at and say, well, why is it the federal government contractors are, riding the gravy train again or whatever, right? People are going to make arguments even though it's just there's real good reasons to do it, to make sure that the industrial base and that the employees are kept and whatnot. So that's why the guidance has been vague, but the intention is clearly to do this to the maximum extent practical.
And Sai, if you are a subcontractor, presumably you'd be working through the prime?
Yeah, and so the prime, assuming it fits this definition that it was a shutdown site or you can't telework, the prime should be going to the contracting officer and saying, even if it's arguably a partial shutdown, it's any of the employees that are impacted. It's not necessarily the contract, right? It's about the employees. So if the employees have been impacted and you can't work and you can't telework, but the contract is still live, or the prime has shut you down, you should be able to go through the prime to do that. And I know there's a number of large primes that immediately put stop work in place. And we don't even know if their contract was shut down or not. They might have just been doing it to save costs. I think this might be a way also to talk to your primes about, look, can you help me go to the contracting officer and try to get this sort of payment and work with your primes.
Yeah, and just a point of clarification, we got a question about whether whether the contractors being reimbursed for under the contract for leave is the same as, the government is going to pay for the FCRA leave, the sick leave that applies if you're under 500 employees and does not just apply to government contractors. And so correct me if I'm wrong, but this is a separate situation than FCRA leave altogether. The relief for contractors is supposed to be if the contractor can't otherwise continue operations because the site's shut down or there's a stop work order or something to that effect, right? That's not the same as under FCRA, which is leave that is supposed to help somebody when they're actually ill, caring for somebody that's ill or their kids are home from school, but the contract is otherwise running and humming along, or the work is otherwise humming along. And that's what the FCRA leave is supposed to be for, as opposed to the contractor bucket of payment, which would really be if that site is shut down. Is that your understanding as well, Sai?
Yes, exactly. And I've also heard people ask about, well, if I got a stop work order already, can I still use this or can I still make the arguments? I don't think the reason for the shutdown at the facility, right? As long as the facility is shut down, whether yours or someone else's, or if you're working at a prime, if it's an approved government site or an actual federal site, if those things are shut down, then whether or not you got a stop work order or they didn't give you an official stop work order and you just were locked out of the building, either way, this would still apply so long as it is in relation to COVID, which most likely it is.
Dave or Sai, can you speak to, and this is going back to the PPP loans and the 500, I know there's a lot of discussion around affiliation, and I've got a couple questions about affiliation for tribal purposes and whether, those rules will still apply so that tribes can, the tribally owned entities can be considered on an individual basis.
Yes, it's under 13 CFR 121.301, which is important to note, because if everyone's aware of 121.103 and the affiliation rules in there, those are for procurements. Now we're talking about loans. So it's a different section. It's 301, 121.301. But there as well, it does take into account for affiliation purposes, tribal entities having special protection.
Great. I've got a question about 1099s and whether you can consider 1099 payments to factor into your loan totals. Dave, it's my understanding that that is permissible to include in the loan and the cost for forgiveness. Is that your understanding as well?
Yes, that's correct.
Okay. And what about business owners? Is there any sort of relief available to the business owner themselves?
Well, there is, in addition to these eligible entities that we talked about, a provision in there for sole proprietors and independent contractors who they themselves are missing out on their salary income earnings from self-employment, that they additionally are able to make an application for this loan.
Okay. There seems to be a lot of confusion about why you can access the loan application but not actually get the loan yet. Can you speak to what the understanding is out there with respect to whether any lenders are accepting these applications at this point?
I mean, I can speak to the fact that, Treasury released the draft loan application, but each lender has to, adopt it and put their own underwriting and process to make sure that the certifications and the analysis that they do is in place. So the loan application is just the kind of the first step. Now the banks are doing everything on the back end to make sure that they can process it and actually get through it. I think it was just circulated so that everybody could start getting prepared, because as you had mentioned previously, the intent of the program is to get as much money out as fast as possible. So to the extent that people can start working on their loan applications and gathering their payroll cost documentation and tax filings and charter, they should start doing that. But it's from everything that we've heard from our banking relationships, they have not been given the green light. And so they're not going to start loaning out these funds until the SBA guarantees that they will get the guarantee under the SBA program.
Which makes sense. Mm-hmm. There's some questions about concerns around being able to spend the money, so to speak, in an 8-week time frame. Do you know if it has to be just an obligation that's incurred during that 8-week time frame? So my payroll doesn't come until 2 weeks, might be 2 weeks after I've incurred the payroll cost. Do you know anything about how, and recognizing everyone out there that we're at the infancy and probably will get more meat on the bone, so to speak, as we go forward. But if you incur the cost in the 8 weeks, even if it hasn't been paid out, do you know if that would still count?
Yeah, I think that we're wait to see what additional guidance, but under the plain text of the CARES Act, it's payments actually made during that 8-week period, not necessarily it's incurred and made. And so you have to be able to demonstrate that it was paid out during that period. So hopefully there's some additional guidance to kind of work with the practicalities of payroll cycles. But as of yet, we haven't seen anything.
And what about, this dates back to essentially February 15th. So there are several questions about understanding that has to be money that's paid out during that 8-week period following when you receive the funds. But if you laid some people off in March, can you go back and make them whole and then apply for loan forgiveness as long as you paid it during the 8-week period?
I suppose potentially as a payroll cost is pretty broadly defined with regards to salaries, wages, bonuses and commissions. So, you could constitute, I would probably say you could consider it or categorize it as, say, a sign-on bonus or a retention bonus upon rehiring the person to make them whole, and therefore pay that out during the 8-week period. That I think you could find a way to do that.
And Cy, when we're talking about the government contractors going to contracting officers and understanding that there isn't a lot of information out there other than the text of the law itself and the OMB memo, do you have any advice for contractors as to how to best educate contracting officers?
Yeah, I think focusing on some of the key language in, say, the memo, or in particular, the OMB memo or the DoD memo, about them they should be empowered to do whatever is necessary in their best, business judgment. And really the purpose behind all of these acts and memos, I would focus on those, and then also break down for them their legal ability to get money from anywhere, which it clearly says in the act, and how they're supposed to do it at the minimum applicable billing rates, not costs, and putting together that sort of an educational memorandum, basically, or request for them. But then even more importantly, after you go through that, is giving them what they should do, right? I would come to them with, it says minimum applicable rates. This is our rationale for why it was. And if you have rates, be like, here's our rates in the contract. If you don't have rates, I would be prepared and maybe try to put in some reasonable profit, but I would be prepared to put together actual rate structures and explain somewhat how you built those up, so that it doesn't seem like you're trying to do like a cash grab or something, which I think some COs are going to be wary about if there aren't rates already in the contract.
Fair enough. We have a couple of questions about the sick leave. One, particularly for employees that are under 50 employees and might want to take advantage of the exemption, and whether or not they're still going to be on the hook for the 80 hours of sick time. And the answer to that is yes, that generally speaking, you cannot get an exemption for the 80 hours of sick time, even if you're under the 50 employees. It really only applies to the child care provisions. And if you want to take advantage of the exemption for the child care provisions, the standard is very high to show that the viability of your business will be threatened. And that means that you would not be able to, all of your employees would be taking the leave at the same time, and it would effectively shut down your business. You couldn't pay for it in advance of getting the Social Security tax credit. And there are a couple of examples on the Department of Labor website. So just understand that exemption is high, and it only applies to the child care provisions of the family leave. And then there's a question about being sued if you're under 50 employees. There is a provision that indicates that if you're under 25 employees, you might not be subject to, lawsuits in the general, federal sphere, but you would still be subject to Department of Labor audits. So just keep in mind that it's not always about getting a lawsuit. It's also about having a Department of Labor auditor at your doorstep, looking at all of your business and wage and hour practices, not just your sick leave practices. We are out of time. It's 3 o'clock. I know we received a lot of good questions. We will take a look at the questions and get back to you if we can. Please keep in mind that, we can't give specific business advice. This is our beautiful faces right here, and we can't give you specific legal advice or create an attorney-client privilege over the internet. All of your factual situations, if we've learned anything over the last 2 weeks at all, it's that everybody's situation is just a little bit different. What you're going through is similar in that everybody's having their own hardships and their own ways to navigate through this crisis, but everybody's situation is unique, and you need to kind of put together a package or a game plan that works for your situation, and what contracts that you might have going on, what business might be affected by this. So we highly suggest that if you have any specific questions about the loan programs or what's in CARES, that you seek counsel, and go from there. Thank you so much for joining us today. We really appreciate it. You have our email addresses and our contact information. We have a wealth of information up on our website, on our COVID Resource Center. We are trying to frequently post updates to that, and to push information out to you all as quickly as we possibly can. If there's something you would like to hear from us about, please let us know. And other than that, stay safe out there and have a great afternoon.